Good evening guys, this is Nikhil from the BLB second year student and I am here to presenting my presentation on the topic which is given by the Officers Committee which is cybercrime. So let's start. Cybercrime, also known as internet law or digital law, is a specialized branch of the law that governs the legal issues relating to cyberspace, the internet, and the use of information from combating sophisticated cybercrime like hacking, identity theft, protecting personal data, privacy, and safeguarding intellectual property in the digital sphere. The first cyber law was to be existed is Cyber Fraud and Abuse Act of 1986. Cyber law deals with the legal aspect of the crime cyberspaces, the internet, computing, and broader view. Cyber law handles the issues of intellectual property, content protection, data protection, privacy, freedom of speech and expression in digital space. If we move to the next slide, is the type of cybercrime. The first type is cyber stalking. Stalking is for cyber law is the usage of the entity, social media or online information to threaten or stalk or extort money from them. The data collected by the attacker is generally sensitive and can cause issues such as security breaches, defamation, and more. Then second type is phishing. Phishing is a crime where the hacker gains access to the personal device via link. The link is a simple glance to look authentic. The link can include gift card, games, etc. Then third one is online fraud. Online fraud is a cyber law in India identify the theft, identities, credit card, and other financial based crimes and fraud. Then fourth one is financial fraud. Financial fraud happens when someone deprives you of your money or otherwise harms your financial health through misleading, deceptive, or other illegal practice. Then the last one is identity theft. Identity theft, as per the cyber law, is the stealing of someone's identity and passing it off as your own in an online forum. This is a serious concern in the cyber law because the hacker steals your private and confidential information and use same for the malicious game. Then the next slide is legal provision relating to the cyber law. The first legal provision is the Information Technology Act of 2000, in which section 43 deals with the penalty or damages sustained by the computer system without criminal intent. Then the section 66 deals with the computer related offences generally. Then the 66 to 66b to 66f is miscellaneous cybercrime offences involve identity theft, data theft, and cyber terrorism. Section 67, 67a, 67b deals with obscenity and child pornography. And the section 69 is to provide the government with the authority to intercept information. Then we move to the Bharatiya Nyaya Sanhita. There are certain legal provisions which is given by the Bharatiya Nyaya Sanhita and the BNS. Also, in this first section is section 75, which deals with the sexual harassment. And the section 77 is voyeurism. Section 78 is stalking. Section 111 is organized crime, and the section 316 is digital theft, and the section 318 is cheating. Section 152 is a threat to national sovereignty. The next slide is myth about the cybercrime. Myth 1 is small business are not target for the cyber attack. Reality, cyber criminals often target small business precisely because they believe these companies have weaker security measures. Myth 2 is antivirus software is enough protection. While the antivirus software is essential, it is just one layer of protection but not the whole. The next myth is strong passwords are enough. The strong passwords are vital, but relying solely on them is risky. Multi-factor authentication (MFA) is necessary for the second layer of protection. Then the last slide of our presentation is a case law, which is Sreya Shringal versus Union of India AIR 2015, Supreme Court 1523. In this case, under the Article 32 of Indian Constitution, 10 criminal and civil petitions were filed in the Honorable Supreme Court of India. These writ petitions raised concerns mainly about the provision of the Section 66A, 69A, and the 79 of the Information Technology Act of 2000. Section 118, subclause D of the Kerala Police Act with respect to the freedom of speech and expression guarantee under the provision of the Article 19, subclause A and the subclause 1 of A of Indian Constitution, where the judgment and the decision of this case is the Section 66 of the IT Act is struck down unconstitutional for violating Article 19, subclause A and not saved by the Article 19 of subclause 2. Section 69A and the Intermediary Guideline June 2011 were upheld as constitutional provided due to safeguards are followed. Section 79 intermediary liability was written down intermediaries are only required to remove the content when ordered by the court or the government authority. Thank you.